Good afternoon, class. My name is Paris Underwood. This is Law 5723. My presentation is on the Quinault Indian Nation, and I will be covering their tribal history and tribal court. This is the seal of the Quinault Indian Nation and the Quinault Treaty of 1856. The Quinault Indian Nation history. The Quinault Indian Nation is located on 208 150,000 acres of land in the Olympic Peninsula and enjoys 23 miles of sovereign Pacific coastline. The Quinault Treaty was signed by Isaac Stevens, governor of Washington Territory, and the Quinault chief Tohola, and the chiefs of the surrounding tribes on the Quinault River on July 1st, 1885, and then signed again at Olympia on January 25th, 1856. The sister tribes of the Quinault are the Queets, Quinault, the Hoh, the Chehalis, the Chinook, and the Cowlitz tribes. On August 24th, 1922, the Quinault people decided to document and shape the Quinault government in the bylaws of the Tribal Council. President Harry Shale and Agent W.B. Sam would sign the document into law. Under these newly created bylaws, the Quinaults would establish an elective government ruled by the Tribal Council, made up of voting members of the nation and business committee. The Tribal Constitution was approved in 1975, which created the foundation for today's modern tribal government. The business committee was made up of a president, vice president, secretary, treasurer, and 7 councilmen or councilwomen. Certain legislative powers were placed in the tribal council, and certain legislative and executive powers were placed in the business committee. In the following 43 years, the tribal document outlining the government would continue to evolve. The Tribal Council would formally ratify and amend its bylaws to provide greater definition of powers vested in their Tribal Council and Business Committee. These new bylaws would be signed into effect on May 22, 1965. Here is a picture of the state of Washington and the location of the Quinault Indian Reservation, which, as you can see, is located on the Pacific coastline. The Quinault tribal structure consists of a president, vice president, treasurer, secretary, and 7 council members, which will either be men or women. The Quinault Indian Nation Government Center and the tribal court is located within the government building. Their location is the Quinault Indian Nation Tribal Court, P.O. Box 99 or 136 Houghton Street in Tohola, Washington, 98587. Under Title V, Courts and Judiciary, this gives the tribe judicial powers, the Court of Appeals, the Quinault Tribal Courts, judges, clerk, duties, records, and other court personnel. The tribe does not offer traditional courts or traditional practices today. They practice traditional customs previously by tribal judges, but they have a current non-Indian judge who does not want to use traditional customs. He follows county and state laws in addition to tribal codes. The court was founded in around 1975, and they have changed over time with the tribal codes as the tribe rewrites their titles. Title 12 and Title 30 are being rewritten currently, as many of the laws in the tribal code reflect county and state laws, and the court and staff with the judge rule strictly by these state laws. For an attorney to practice law in the Quinault Tribal Court, they must have a valid QIN business license as approved by Title 40 of the Quinault Tribal Code. In addition, they must be current with the required QTC annual bar dues, which is $50. Currently, Judge Pinori, I don't know how to pronounce his name, is the tribal court judge today, and he is a non-Indian judge from Grace Harbor County Court. Judge Pinori does not utilize traditional tribal customs in his court, and in order to be admitted to the Quinault Tribal Court bar, pursuant to QTC section 30.12.030, you must already be a member in good standing of the bar of any state of the United States or the District of Columbia. And you must complete an application for admission, and the fee for that is $75. There are currently 19 attorneys licensed to practice in the Quinault Tribal Court. The Quinault Tribal Court mission. The court's mission is to fully implement the statutory delegation of general jurisdiction judicial power from the Quinault Nation Business Committee, consistent with the sovereign powers of the Quinault Nation. The court staff, both judicially and administrative, shall ensure the fair and equal administration of justice on the Quinault Reservation and for litigants before the court. Staff must ensure a process that will assist the Quinault Indian Nation and all of its departments in ensuring the health, safety, and welfare of the Quinault people and visitors to their homelands. Title V is their courts and judiciary. Section 1 is their judicial power. Section 2 is their Court of Appeals. 3 is the Quinault Tribal Court. Section 4 is their judges, their clerk, duties, records, and other court personnel. Title 12 of the criminal offenses, Chapter 1, criminal offenses. Chapter 2, penalties and sentencing. Chapter 3 is their principles of liability. Chapter 4, defenses. Chapter 5, anticipatory offenses. 6, offense against persons. Chapter 7, offenses against property. Chapter 8, offenses against public order. Chapter 9, offenses against the family and domestic violence. Chapter 10, drug and alcohol offenses. Chapter 11, sex offenses, sex offender registration and notification. Chapter 12, miscellaneous offenses. Chapter 13, weapons offenses. Chapter 14, motor vehicles. Chapter 15, limitations of actions and forfeiture hearings. The tribal court. I have not been able to locate information on tribal court history pre-IRA and much on the post-IRA other than it was established around 1975. The tribe had 3 tribal judges since its foundation, 2 of which were Quinaults and 1 was a Colville. These tribal judges used traditional tribal practices and restorative justice while on the bench, and the tribal council have said that it worked. They currently have a non-tribal judge who does not choose to use tribal customs. They do have a trial court, appeals court, child custody, adoption, civil and criminal court, or a general jurisdiction court, meaning that they hear all types of actions and proceedings. With their current judge, as I've said, Pinori, the tribal court reflects state court standards versus using more of a tribal traditional system. They have tribal appointed attorneys for indigent persons. Prosecutors and other court appointed attorneys are represented under the Quinault Bar admissions, and they travel to the reservation for trial. The tribe has a tribal police force, tribal attorney who represents the tribe in federal cases, and the website does not offer any information on court costs or the filing process. I had little luck with attaining information from tribal officials as they were reluctant to share tribal information. So most of the information I discovered were from the tribal website, and from non-Quinault websites. The Quinault Indian Nation Tribal Constitution, Article 1, Sovereignty, Article 2, Enrollment, Article 3, General Council, Article 4, Business Committee, Article 5, Power and Responsibilities of the Business Committee, Article 6, Ratification, Article 7, Amendment, Article 8, Enforcement, and Article 9, Approval of the Secretary of the Interior. The Quinault Indian Nation Tribal Code has bylaws, which is the Article 1, Officers, Article 2, Powers, Article 3, Reserved Powers, Article 4, Meetings, Article 5, Public Hearings, Article 6, Duties of Officers, Article 7, Committees, Article 9, Amendment, Article 10, Oath of Office, and Title 5 is the Courts and Judiciary, Title 12, Criminal Offenses, Title 14, Elder and Adult Code, Title 17, Exclusion and Removal, Title 18, Public Nuisance Code, Title 19, Domestic Relations, Title 20, Involuntary Treatment, Title 22, Probate Procedure, Title 30, Rules of the Quinault Tribal Court, Title 30A, Rules of Criminal Procedure, Title 30B, Rules of Civil Procedure, Title 31, Court of Appeals Procedure, Title 39, Eviction Procedures, Title 40, Business Licenses, Title 40A, Tax Refund, Title 41, Fireworks Control, Title 42, Regulations of Motels and Other Businesses, Title 43, Cable Television, Title 48, Land Use and Development Code, Title 51, Fishing, Hunting, Gathering, Title 52, Beach Lands Ordinance, Title 53, Fish Tax, Title 55, Children's Code, Title 56, Truancy Code, Title 60, On-Site Sewage Disposals, Title 61, Natural Resources Management, Title 70, Gaming Ordinance, Title 70B, Lottery Ordinance, Title 71, Liquor Ordinance, Title 80, Housing Authority, Title 81, Leasehold Mortgages, Title 82, Prevailing Wages, Title 86, Tobacco Control, Title 96, Workers' Compensation, Title 97, Tribal Employment Rights, Title 98, Animal Control, Title 99, Statute of Limitations, and Sovereign Immunity. In this section, I will be covering the articles under the Quinault Treaty of 1856. Article 1, the said tribes and bands hereby cede, relinquish, and convey to the United States all their right, title, and interest in and to the lands and country occupied by them, bounded and described as follows. Commencing at a point on the Pacific coast, which is southwest corner of the lands lately ceded by the Makah tribe of Indians to the United States, and running easterly along the southern boundary of the said Makah tribe to the middle of the coast range of mountains, thence southerly with said range of mountains to their intersection with the dividing ridge between the Chehalis and Quinault rivers, thence westerly with said ridge to the Pacific coast, thence northerly along said coast to the place of beginning. Article 2, there shall, however, be reserved for the use and occupation of the tribes and bands aforesaid a tract or tracts of land sufficient for their wants within the territory of Washington, to be selected by the President of the United States and hereafter surveyed or located and set apart for their exclusive use, and no white man shall be permitted to reside thereon without permission of the tribe and the Superintendent of Indian Affairs or Indian Agent. And the said tribes and bands agree to remove to and settle upon the same within 1 year after the ratification of this treaty, or sooner if the means are furnished them. In the meantime, it shall be lawful for them to reside upon any lands not in the actual claim and occupation of citizens of the United States, and upon any lands claimed or occupied, if with the permission of the owner or claimant, if necessary for the public convenience, roads may be run through said reservation on compensation being made for any damage sustained thereby. Article 3. The right of taking fish at all usual and accustomed grounds and stations is secured to said Indians in common with all citizens of the territory, and of erecting temporary houses for the purpose of curing the same, together with the privilege of hunting, gathering roots and berries, and pasturing their horses on all open and unclaimed lands, provided, however, that they shall not take shellfish from any bed staked or cultivated by citizens, and provided also that they shall alter all stallions not intended for breeding, and kept up and confine the stallions themselves. Article 4. In consideration of the above section, the United States agreed to pay the said tribes and bands the sum of $25,000 in the following manner. That is to say, for the first year after the ratification thereof, $2,500 for the next 2 years, $2,000 each year. For the next 3 years, $1,600 each year. For the next 4 years, $1,300 each year. For the next 5 years, $1,000 each year. And for the next 5 years, $700 each year, all of which sums of money shall be applied to the use and benefit of the said Indians under the directions of the President of the United States, who may from time to time determine at his discretion upon what beneficial objects to expend the same, and the Superintendent of Indian Affairs or other proper officer shall each year inform the President of the wishes of said Indians in respect thereto. Article 5. To enable the said Indians to remove to and settle upon such reservation as may be selected for them by the President, and to clear, fence, and break up a sufficient quantity of land for cultivation. The United States further agree to pay the sum of $2,500 to be laid out and expended under the discretion of the United States, and in such manner as he shall approve. Article 6. The President may hereafter, when in his opinion the interest of the territory shall require, and the welfare of the said Indians be promoted by it, remove them from said reservation or reservations to such other suitable place or places within said territory as he may deem fit, on remunerating them for their improvements and expenses of the removal, or may consolidate them with other friendly tribes or bands, in which latter case the annuities payable to the consolidated tribes respectively shall also be consolidated, and he may further at his discretion cause the whole or any portion of the lands to be reserved, or of such other land as may be selected in lieu thereof, to be surveyed into lots and assigned the same to such individuals or families as are willing to avail themselves of the privilege, and will locate on the same as a permanent home on the same terms and subject to the same regulations as are provided in the 6th article of the Treaty of the Omahas, so far as the same may be applicable. Any substantial improvements heretofore made by any Indians which they shall be compelled to abandon in consequence of this treaty shall be valued under the direction of the President, and payment made accordingly therefore. Article 7. The annuities of the aforesaid tribes and bands shall not be taken to pay the debts of individuals. Article 8. The said tribes and bands acknowledge their dependence on the government of the United States, and promise to be friendly with all citizens thereof, and pledge themselves to commit no depredations on the property of such citizens, and should any or more of them violate this pledge, and the fact be satisfactorily proven before the agent, the property taken shall be returned, or in default thereof, or if injured or destroyed, compensation may be made by the government out of the annuities, nor will they make war on any other tribe except in self-defense, but will submit all matters of difference between them and other Indians to the government of the United States or its agent for decision, and abide thereby. And if any of the said Indians commit any depredations on any other Indians within the territory, the same rule shall prevail as is prescribed in this article in case of depredation against citizens. And the said tribes and bands agree not to shelter or conceal offenders against the laws of the United States, but to deliver them to the authorities for trial. Article 9. The above tribes and bands are desirous to exclude from their reservations the use of ardent spirits, and to prevent their people from drinking the same, and therefore it is provided that any Indian belonging to the said tribes who is guilty of bringing liquor into said reservations, or who drinks liquor, may have his or her proportion of the annuities withheld from him or her for such time as the President may determine. Article 10. The United States further agree to establish at the General Agency for the District of Puget Sound within 1 year from the ratification hereof, and to support a period of 20 years in agricultural and industrial school, to be free to the children of the said tribes and bands in common with those of the other tribes of said district, and to provide the said school with suitable instructor or instructors, and also to provide a smithy and carpentry school, and furnish them with the necessary tools, and to employ a blacksmith, carpenter, and farmer for a term of 20 years, to instruct the Indians in their respective occupations. And the United States further agreed to employ a physician to reside at the said central agency, who shall furnish medicine and advice to their sick, and shall vaccinate them. The expenses of the said school, shops, employees, and medical attendants to be defrayed to the United States, and to be and not deducted from their annuities. Article 11. The said tribes and bands agree to free all slaves now held by them, and not to purchase or acquire others hereafter. Article 12. The said tribes and bands finally agree not to trade at Vancouver's Island or elsewhere out of dominions of the United States, nor shall foreign Indians be permitted to reside on their reservations without consent of the superintendent or agent. Article 13. This treaty shall be obligatory on the contracting parties as soon as the same shall be ratified by the President and Senate of the United States, in testimony whereof the said Isaac I. Stevens, Governor and Superintendent of Indian Affairs, and the undersigned chiefs, headmen, and delegates of the aforesaid tribes and bands of Indians have hereunto set their hands and seals at Olympia, January 25th, 1856, and on the Quinault River, July 1st, 1855. Isaac A. Stevens, Governor and Superintendent of Indian Affairs. Tribal sovereignty. Tribal sovereignty is important as it allows the tribe to determine their own self-governance. It allows the tribe to determine their judicial system, pass their own laws, traditional customs, to incorporating state laws within their tribal codes, enforcing laws through police and courts. Tribal sovereignty quote by the former late Quinault Indian Nation President Joseph Delacruz, 1937 to 2000. He is quoted as, No right is more sacred to a nation, to a people, than the right to freely determine its social, economic, political, and cultural future without external interference. The fullest expression of this right occurs when a nation freely governs itself. And that is my presentation. Next is a couple of pictures of the Quinault Nation, followed by my citation sources. This is my presentation. I hope you enjoyed it. Thank you for listening, and have a great day.